Good afternoon, and thank you everyone for attending today's webinar, How to Respond to an Audit, presented by Guillermo Bettis of Kern, Augustine, Conroy, and Shopman. Please be aware that there will be a question and answer portion today at the end of the webinar. To avoid frequent interruptions during the webinar, please type your questions in the question box located on the right of your screen. They will be answered in the order received during the question and answer portion. Additionally, an electronic version of this presentation will be emailed to all participants following completion of today's webinar, and a recorded version will be available on the website for members only. Again, NJMGMA would like to thank you for attending, and I will now turn things over to Guillermo.
Good afternoon, everybody. My name is Guillermo Bettis. I'm an attorney at Kern, Augustine, Conroy, and Shopman. I'm talking to you today about how to respond to an audit. It's an issue that every practice will go through, whether it's an innocuous audit that you go through based on a provider agreement that you have with a private insurer, or something invasive like a RAC audit, or what we're seeing now, OCR's Phase 2 HIPAA audits. So this will focus mostly on how to respond to Medicare audits, because what you learn here today about how you get on the radar, how to respond, and how to avoid being one of these red flags that gets picked up is really applicable across the board if you're being investigated by Medicare, a private insurer, or a Medicaid fraud division in New Jersey, for instance. So regardless of the entity, they follow pretty much the same steps and processes. So the first thing I'd like to talk to you about is what you can expect. So what can you expect? The number one question that I get from my clients when they come in, and I have a practice manager on the phone, or I have a doctor in front of me, and they're asking me, well, how was I, the target? Why am I here today? And there's really, a myriad of reasons why you could have been chosen to be the target of an audit. But there are particularly three that we see a lot, and three that are pervasive in healthcare. So the first one is electronic records. Now, electronic medical records, they're a double-edged sword. They're actually very good, and the reason why a lot of practices use them is because they're good. They do help with patient care. They do help with audits, believe it or not, because in the past you would have a lot of doctor services being denied, not because they were not medically necessary, not because they were double billing, not because they were unbundling, not because they were doing anything wrong, but because the reviewer simply couldn't read the doctor's handwriting. So legibility alone has helped a lot of practices. However, there are some particular issues that EMR brings when you're considering how are my records being audited, how is my EMR being audited. Data entry can be time consuming. This is one thing that we've noticed with a lot of practices. It takes time away from the patients. So the physician, caring about the quality of care, not necessarily the quality of his or her data entry, might carelessly check the wrong box, might not put in too much effort on the computer, the computer terminal that's in the room with the patient, because they'd rather focus on being with the patient, which is something that's, as a patient, is something that you like. But unfortunately, doctors need to understand more and more that data entry is the new documentation standard. How well you enter the data into the EMR, that's how good your documentation is going to be. The one thing that any healthcare attorney will tell you is that a document is your shield. Your documentation is your shield against allegations of fraud and abuse, against audits, against malpractice suits. So it's very important that your electronic records are given the importance that the old school handwritten records were. One thing that we do also see a lot is fast and sloppy, inputs. Again, a mischecked box can change the nature of the visit completely. Just blind box checking because it yields a higher code, that's also wrong, and that's fraudulent, because you need to only check the boxes that apply, and unfortunately, sometimes you have to, type into a field, into a box field, some additional information, and there are physicians who are just uncomfortable doing that and just rather check a box and move on. These things can have disastrous results, because if you're checking the wrong box and you're outputting a higher code and you're targeted for upcoding, or you're targeted for using a wrong modifier, what's going to happen is they're going to look at every single EMR where you build the same code, and where they see that you consistently fail to put in additional information where it's required in a box where you have to type in something, or where you're checking, unfortunately, blindly or just habitually the same boxes, it starts to look like, you're doing this fraudulently as part of a scheme. This is what we're hearing a lot from auditors. Another thing to be worried about with EMR that can be a red flag is templates. A lot of these templates have pre-populated fields. So let's say Jane Doe comes in for a follow-up visit, and all the information from her last EMR visit is populated now into her new EMR visit. So the new documentation for the second visit is pre-populated. This can lead to a lot of errors. This can lead to the record looking like it's out of order sometimes, because if you have someone coming in for the exact same reason as the time before, when really they're coming up for a different type of reason, or if for some reason medications that were previously prescribed keep getting repopulated and you don't take out the medication once the patient stopped taking that medication, you get to the point where at the end of a year or two, you have one patient with 30 different medications, some may be contraindicated, and if there's ever an issue with that patient, someone's going to look at those records and they're going to say, something's up here. We had an issue with an administrative law judge once, where the administrative law judge was looking at the medical records, their EMRs, and they self-populated. So what ended up happening is when the ALJ looked at the medical records, and particularly when she looked at the medications, she saw that there were probably 20 or 30 medications listed, even though the patient was not actively taking, most of them. I think she was only taking about 6 or 7 of them, not 30 of them. But it was never taken away. So what happened? If the ALJ can't rely upon that part of the record, they can't rely on any part of the record. And that led to an unfavorable decision. So accurate record keeping, accurate data entry, data deletion when something's no longer relevant, that's very important. It's also easier to audit EMR because they are easier to read. They're time-stamped, so when you have a time-based code, it's hard to fluff the numbers because the numbers are right there. If you do not meet the 15-minute requirement, 25-minute requirement, if it's a time-based code, that can easily be picked up. And again, you always want to be careful with EMR that generates its own CPT billing codes. Sometimes because you check enough boxes and you get a higher CPT code, that doesn't mean that that's the proper code. You should always have a coder take a look at it, or someone who's trained in billing and coding. Another issue we have it less because we represent practices, not hospitals, but larger practices and hospitals, and to a small extent, smaller practices, get audited when you have a disgruntled employee who gets fired or who learns of an improper billing scheme and they become whistleblowers. Whistleblowers have become incredibly popular in the last 5 years. The reason for that is because every time you submit a fraudulent claim, and fraud is very loosely defined, what you end up having is a $5,000 per claim penalty So if you're submitting hundreds of claims a month and you're doing it fraudulently for years, the penalties alone, I mean, they're draconian, they're archaic. The penalties far outweigh the actual billed amount. And on top of that, they get tripled because you get treble damages under the False Claims Act. So a lot of whistleblowers are now turning on their employers, be they disgruntled or just find out about a fraud, because they get, as a whistleblower, they can get 15% of what the government recovers. And every time you see a whistleblower case announced on the news, you know, it's in the millions of dollars. And the verdicts are rarely, you know, low six figures. So that's another thing to, you know, always, you know, be aware of. But the one thing that brings the most practices to our office and offices across the state of New Jersey is being an outlier. In the very simple statistical term, an outlier is obviously someone who, if you look at a bell curve distribution where the bulk of you know, whatever society, you know, is in the center, an outlier is to the right. They're that top 5%, 10%. You know, it's those practices that bill the most of a particular code, a particular modifier, prescribe the most narcotics. Someone has to be number one, and unfortunately, we are in a state now in medicine where there's an attack on medicine, there's a collective war on doctors from the state and the federal government and private insurers who are all working together, and they're targeting outliers in particular. So, you know, they try to compare what they consider to be similar practices or similar physicians, but a lot of times what we have found is that they don't have the right sample size because their patient populations are different. The practice that, you know, is an outlier is a lot of times a busy practice. Sometimes they offer something unique, like they're the only, you know, Korean, fluent Korean speaking doctor in a, you know, ethnic area that has a lot of Koreans. You know, we've seen those types of situations where, you know, the records alone show that this person's an outlier, but if there's a particular reason why, you can defend that. But those are three of the big reasons why you will end up, unfortunately, the subject of an audit. If your electronic records give you up, if you have a disgruntled employee who's blowing the whistle on you or just reporting you out of, you know, spite, and if you're an outlier for any reason. So how are traditional Medicare audits conducted? Well, the first thing they'll do is that they'll request some records from you. A lot of times, physicians, you know, and office managers ask me, well, when should I be concerned about a medical records request? Typically, it's in the size of the production. If they're asking for 5 to 10 records, that's not something to worry about. You know, usually a small sample isn't statistically relevant, so they wouldn't be able to extrapolate. They wouldn't really be able to say that they did a statistically random valid sample that would allow them to then use the findings as part of an overpayment demand. If it's 5 to 10, it might be something routine, which does happen, and it's not something that should raise any red flags. If they're asking for 50 records, for instance, that's usually enough for a statistically valid random sample. Anywhere in the 30 to 50 range between those, that might be cause for concern. You might want to, you know, reach out to a healthcare counsel or a biller just to make sure that you're doing everything correctly. There's also medical record inspections where they'll just show up to your office and they copy your own documents. Now, the one thing to really remember about this is that if someone comes to your office and they want to copy your records, and you have EMR and you can just download them, when they they're not supposed to sit down and take control of your computer and your EMR. They're only allowed to access those patients that are Medicare patients, for instance, or if it's Horizon, only Horizon patients. They're not allowed to just get your password and then just start searching through your computers. They try to do that sometimes. So if someone comes to your office and they want your EMR, easy. have them give you a list, or they could look over your shoulder while you access the particular patients that are at issue. They should not be allowed to just roam through your system by themselves. So you have to make sure when someone comes to your office to copy or download records, did they copy or download all the relevant documents? Did they take the lab work that supports a change of medication, for instance? Did the practice maintain a copy of the records copied by Medicare or a private insurer? That's very important, because if you later want to assert a defense that they did not take into account certain information, you really need to know, and most importantly, your attorneys need to know exactly what was sent or what was copied or what was downloaded by Medicare or a private insurer. That's very important to your defense, because if you don't know what they have, the other way to put it is you don't know what they don't have. And what they don't have is what could save you in an audit. Another thing is you also want to, just to finish up that last point, you also want to make sure that you maintain a copy of your records, because a lot of times records get misplaced. If you have to send them in, if you have to mail them out, a lot of times they get redirected to the wrong place, or someone states that they didn't receive them, but then, if you send it by a means that you can track, by trackable mail, FedEx or certified mail, you should always keep a receipt of that, because, we've had issues where Medicare has said in the past, oh, we never received it, but in fact they have. So what do you expect at the initial determination? This is after you've sent the records out or they've come in and copied records at your office. Well, the first thing is you get a letter from them that's going to give you a summary of their findings. It's going to discuss what they found, the records they reviewed, what they reviewed them for, if it was for a modifier or for a particular CPT code. And then you want to consider whether the claims really were submitted properly or improperly. This is something that might require the help of an outside billing company, an outside coder. And then with the help of an outside coder, you can consider whether the documentation really does support the codes billed and the levels of the CPT codes billed. One thing to keep in mind, I've mentioned a couple of times about consulting possibly an outside coder. Whenever you consult with anyone about fraud investigation, fraud audit, or standard Medicare audit, standard private insurance company audit, the one thing to keep in mind is that anything you say to a coder is not privileged. This is one reason why a lot of times practices will first contact a healthcare attorney. Through the healthcare attorney, they will then contact and contract a coder, because if the coder provides assistance to the attorney in responding to concerns from the practice and reviewing the practice's records and responding, then that attorney, all the communications between the coder, the practice, and the attorney are privileged and fall under the attorney-client privilege. It may not be necessary, but when you get a demand letter and it starts spewing language and throwing out words like fraud or abuse or waste, you definitely want to consider getting a healthcare attorney involved, even if it's just to oversee the production of documents and advice between you and a coder. The other thing you definitely need to keep in mind is if whenever you contact healthcare counsel or a coder or a biller or anybody else, please make sure that you have HIPAA business associate agreements. The one audit that I won't be talking about today, but that is picking up a lot of steam, is the phase 2 of the Office of Civil Rights, OCR's HIPAA audits. Now these HIPAA audits, they're targeting business associates. They're looking to collect this year essentially between $5 and $8 million. It's a program that's ramping up. Every healthcare attorney has kind of, been harping on this for the last year or two, because we keep getting announcements from OCR saying that they're going to be, reviewing business associates agreements and conducting a HIPAA audit and assessing penalties and fines, and it looks like this is the year that it's really going to ramp up. So please be careful whenever you send out your records to any of your business associates. So after the determination letter, if they determine that the documentation did not support the coding or something was used inappropriately, then the next thing you'll have is an overpayment demand. Now, an overpayment demand typically includes an extrapolation. What that means is, let's say they get 50 records from you. After reviewing your 50 records, they say, okay, well, based on our review of these 50 records, you owe $20,000. This review was for 1 year. We're looking at a 5-year look-back period, so we want $100,000. That's typically how it works. The payment is due upon receipt of the overpayment demand. So at that point in time, if you haven't contacted an attorney, what you should do is consider repayment options. If you think you are dead to rights, and sometimes you are. Sometimes we've had situations where practices use an outside biller, and the outside biller billed the wrong code, a code that doesn't exist anymore because they don't have updated CPT books. Well, there really isn't much you can do at that point. So you may just consider repayment options at that point. Or if you think that you are entitled, or the overpayment demand is so large that you want to try to see if you can in any way negotiate it or get a payment plan or challenge some portion of it, at that point you should consider your challenges, and you may want to get counsel involved at that point. One thing to know about repayment, it's been known that practices that easily repay, like they get a notice of overpayment and just pay it right away, they become targets but for a different way, because they're known to be low-hanging fruit, where if they need any money, whoever it may be, if that practice pays whenever you demand payment without question, you become a target in that sense too. So it does pay to fight, even if you don't win or don't win 100% or still have to repay a portion. You don't want to be the easy target that they go to every time they need to pay, for a holiday party. Don't be that easy target. So if you want to challenge an unfavorable finding, there are a few ways to do it. Usually we try to attack it on all 3 grounds. One is a statistical challenge. Well, how many records did they review? Did they review 10 records and then try to extrapolate? Well, that's not going to be, a valid sample. It's too small of a statistical, sample. You need a statistically valid random sample that's representative of your practice. Otherwise, the sample statistically cannot be supported. There's a billing and coding aspect. Well, okay, so based on what you billed, did the documentation support the level of coding? If it's a medical necessity, you may need to get an expert. I know it sounds a little silly to hire a physician to provide an expert report that your physician could write himself. But again, you have to understand that you got to think of this in the long run. And while the physicians, at your office may be able to explain exactly why they did and why it was medically necessary, if it requires going to the ALJ, having an independent expert who independently looks at this and can back up, the medical necessity, that goes a long way, because there's no bias at that point. There's no perceived bias or suspicion of bias. Procedural challenges, those are simply, was it outside the scope of, of what they initially were looking for? If they were, looking into modifiers, but then they start, seeking overpayment for something else completely unrelated. If it's something outside of the time limit, if they're looking back 15 years, there are different ways that we can attack it procedurally, that you can attack it procedurally. But the main two challenges that you're going to use are statistical challenges and obviously, billing and coding, medical necessity, documentation challenges. So the Medicare appeal, the redetermination level. Okay, so you get an overpayment demand. The first thing you want to do is so the step one, level one appeal, you want them to redetermine because you disagree. So you want to redetermine, their determination that you owe money. Okay, so what do? You have to appeal in time. Medicare will provide you with documentation letting you know exactly when the redetermination appeal is due. You cannot blow that deadline. You have to make sure that you abide by that deadline. They give you plenty of time. I think first level, I believe, is, I'm not even going to guess, but it's no less than 90 days. So you definitely have a considerable amount of time along every single step that we're going to discuss. None of these are, due within 15 to 30 days. You get plenty of time for every single one of these appeals, so you should always try to get them in on time because otherwise you're going to be shut out for procedural reasons. You want to keep copies of all documents, and you want to send the appeal via a trackable method. The appeals follow the same process as the first set of documents that you sent to Medicare, Medicaid, or a private insurer. You want to keep all the documents, and you want to send it through a trackable method because, again, things get diverted, things get lost in the mail, things get put in, the wrong person's inbox, and then who knows where it ends up. So you definitely want to make sure that you always know where your documents are. And then submit the appropriate form. They have some appropriate forms they include that you have to fill out with some additional information. So please make sure to fill those out as well. So if your redetermination comes back unfavorable, then the next level, level 2, is a reconsideration. So a reconsideration level appeal, that's your level 2. That's before a QIC. Now, the QIC is supposed to be an independent contractor, but independent is a fallacy, really. When Medicare hires a contractor to review Medicare's decision and redetermination that you owe money, a lot of times that QIC, as a shock to nobody, will side with CMS. CMS is paying the QIC's bills, giving them cases to review. I'd like to say that you get a fair shake by an independent reviewer, but they're independent in name only, and it's tough to get a really fair and independent determination from them. What's very important about this reconsideration level is that you have to make sure that your records are complete because you may be precluded from introducing any additional information at an ALJ hearing. The reason for that is at this point you're building a record. You're trying to provide all of the information possible, including expert reports that the QIC can use to determine whether, in fact, the denial was improper by the reconsideration, whether the overpayment demand is incorrect. This is what, this is the record that you have to build, because if the QIC upholds CMS's original determination, you're going to have to appeal to an ALJ, an administrative law judge. But the administrative law judge cannot consider anything that wasn't considered by the QIC and that wasn't considered by CMS. You can't have new evidence. You can't get a new expert. So all the information that you need for the ALJ should be submitted here for the reconsideration. So assuming this independent contractor hired by a Medicare sides in Medicare, the next level is going to be an ALJ, an administrative law judge. administrative law judges fall under the Office of the OAL, the Office of Administrative Law. So it's basically the same process. You're going to submit your appeal in a timely, manner. So you have to submit the correct forms. You gather all the evidence that you've submitted before the QIC, and you make sure that you have a real complete record. Because when you file your request for a hearing with the ALJ, and when you eventually have to file your motion, your paperwork, you want to have absolutely everything, dotted, all your I's dotted, all your T's crossed, and you want to have all of your documents ready. So the ALJ, just so you know, that is what we consider to be the first time you get a fair shake, because the ALJ is, completely independent of Medicare, completely independent of the medical board, completely independent of private insurers. But the problem is, because there are so many appeals pending, the backlog to get an ALJ to hear your case is almost 2 years, and it's not getting shorter, unfortunately. If anything, it's getting a little longer. So it's a long haul, it's a long fight, and while you're fighting the ALJ, at the ALJ level, once the QIC rules against you, you will have to start paying back whatever overpayment demand they're alleged that you owe. So understand that you have to pay back CMS, pay your attorney fees, or if you're handling it on your own, and pay your experts. So you have to pay to defend yourself, pay back CMS, and if you win, after 2 years maybe, then you get money back. If you lose, then what can you expect? Well, then you have to challenge the administrative law judge's decision. At that point, that's the first chance you get to go to actual court, not the administrative law process. So you go to a federal court, a district court, but unfortunately, it's very tough to win these cases, and it's very expensive, because federal court is not easy, and it's not cheap, and you have to show that the administrative law judge's decision was arbitrary and capricious. That's a very, very high standard. So it's very important. We always say, get it right at the ALJ hearing, because if you don't, it'd be a very costly endeavor and very hard to overturn. As far as what you can expect from managed care audits, those are audits that we're seeing more that target Medicaid managed care spending. And again, it's the same type of process. It's a record request, and then you have to try to defend any overpayment demand, and you have the same balancing test as with Medicare or any other kind of audit demanding overpayment. What is the settlement value versus what's the value of you litigating this issue. As far as financial ramifications, obviously, if you have a healthcare accountant, it's important to talk to him or her, because your healthcare accountant can give you some important insight as to tax implications of settling versus continuing the fight. So we talked about in general how the audit process works. So how do you respond when contacted? Well, first and foremost, you compile all of your records immediately, and you send them in a timely manner, and you send them appropriately. So why is it in parentheses all? Well, because unfortunately, we've had practices and physicians who have come to us in the past, and they've sent just the bare minimum. If an audit, let's say, is targeting a particular code, and instead of sending 3 or 4 patient visits that support the use of that code on the 4th visit, the doctor, out of spite or whatever reason, decides only to send that 4th visit, which is where he or she billed a particular code that's at issue. the doctor's only hurting himself or herself. You know, you want to send everything that will support. You want to send the supporting lab work, you know, diagnostic studies, whatever it may be, whatever supports the code being billed, that's exactly what you want. So it's not the time to be skimpy. It's not the time to, you know, to be lazy. You want to send as much as possible that will support the codes. Send them timely, because if you don't respond, they'll make a decision on their own. It's got to be appropriately, and the reason we say appropriately is because we've had instances where documents are sent, again, sometimes out of spite. They're sent in a way that's hard to read, which again only works against you because, you know, if it's not legible, then unfortunately it becomes, you know, a denied service that you have to appeal, which makes it even more difficult to get paid on, or to defeat an overpayment demand. We had one physician who actually sent his medical records on red paper. And the reason he sent them on red paper is because you can't copy red paper. If you try doing that on a copier, it just comes out blank. He received a very large overpayment demand. You know, this is not the time to be petty, because you're also dealing with people who can be very vindictive and they control the purse strings. So you really don't want to be able, you want to start off on the right foot by compiling your records, sending them timely, and sending them appropriately. You want to make a good first impression. Again, we can't harp on this enough. You have to keep copies of all the documents you provide, because if at some point in time there's a dispute with Medicare, Medicaid, private insurers, you want to show you exactly what document they relied upon in denying your payment or in seeking their overpayment demand. It's very important that they point to the specific record and that you know that you provided everything relevant, because if you didn't, then you have to supplement. We always urge practices to take preventative measures now. Once a request is received, you got to determine the issues of the audit request. Sometimes they ask for 50 charts and they don't say why. Sometimes they say, we're looking into, you know, an aberrant billing pattern concerning, you know, a particular CPT code, or modifier 25, modifier 52. Okay, so take a look at the charts, take a look at the issue identified on the demand letter, the request letter, and figure out, if you can figure it on your own, if there's an issue. And if there's an issue, change it right away. If there's no issue, then you don't have to make any changes. Again, we're going to talk about RACs right now. You know, everyone's heard about them by now, so the RACs detect and correct past improper payments. It allows CMS carriers to focus on preventing future improper payments. There was I believe a study by CMS that said that in 2008 that they estimated $17 billion of improper payments from the Medicare programs. Now, the thing about RAC auditors is that they have choked the ALJ system with all of the audits, because RAC auditors, as you'll see in this next slide, they have a financial incentive. They get a contingency fee. So they will get a percentage of whatever they recover. So it makes it that much more difficult to get money, to get them to overturn their preliminary decisions. Concerning audits, RAC audits, and those are post-payment audits. There's really two realms, post and pre-payment audits. Post-payment audits, they look at payments that were rendered already, and they try to get money back. They try to identify billing errors, and they claw back money that they already paid out. Prepayment audits, a lot of times, if there's a successful post-payment audit, prepayment audits a lot of times follow them. And prepayment audits can be crippling to smaller practices. A prepayment audit essentially shuts off all income from that one particular carrier be it Medicare or Horizon, until the claims are first reviewed. So what happens is you have to submit your bill with a copy of the medical records. Someone at the carrier will take a look at the medical record and the bill, and once they determine that the bill is correct, then you get paid. This slows down payment tremendously, and this has bankrupted some practices. So the goal is to defeat and fight post-payment audits to prevent a prepayment audit. Prepayment audits, it's very important if that ever happens, that you get involved right away, that you get a coder or a software to scrub your claims to ensure that your claims are 100% compliant and good before you submit them for payment. At this point, you may want to get, I would suggest you get a healthcare attorney that can get you off this prepayment list as soon as possible. Usually you're going to be on prepayment 60 to 90 days, so long as you keep submitting a clean rate of about 90% or more. The better you are, the cleaner your claims, the higher your approval percentage. Usually earlier you can get out. Usually we start requesting that practice be removed from prepayment audit after 60 days, and usually within those 30 days we get a letter or a phone call that the practice will be taken off prepayment audit. If you don't do it correctly, if you try to do too much stuff on your own, or you don't give importance to the prepayment audits, like I said, it could be crippling, and you could be on them for a very long period of time. 60 to 90 days is if you are compliant and you do everything perfect and your future claims are scrubbed and you have an attorney fighting for you. If not, we've had cases where there have been practices that were in prepayment review for 6 to 9 months, and how they survived is beyond me. Another thing to keep in mind, since we're talking about a lot of document demands, document demands are just that. They're demands. They're not a warrant. Someone can't come in and break down your door and take your records. They can't disrupt your practice. If someone requests medical records, you can give them to them in a timely manner, but you're not forced to give them that same day. That's one thing that I wanted to, I know it's a little off topic, but I wanted everyone to understand that, because even if someone comes from, let's say, the New Jersey Medicaid Fraud Division, they can't come in and disrupt patients and log into your system with your password and treat it like a warrant. It's not a warrant. It's the same as a subpoena, and you can ask them to come back another time. So that's something that I want you to keep in mind. So the last part of this webinar is going to be on future audits, how to avoid them. So we've talked about this awful process of being stuck in an audit, and then how to respond to them. So the next logical question is, well, how can I avoid them in the future? Well, the first and foremost thing you want to do is you want to be prepared and you want to stay compliant. A compliance plan is really the best way to keep yourself out of trouble. It's not mandatory. No one's required to have a compliance plan, but best practices dictate that you have one. There are free compliance plans posted on the Office of Inspector General's website. There's free guidance provided by OIG on its website. You can just Google, OIG compliance, or follow the link in the PowerPoint slide here that's going to be provided to you at the end of this presentation. It tells you everything. It tells you about what the OIG is investigating. If you take a look at it, it'll tell you that it targets billing for items and services not rendered or not provided as claimed. The OIG is looking at double billing resulting in duplicate payments, clustering, unbundling, failure to properly code modifiers, upcoding of service, billing for non-covered services as if covered. They have a list of hot topics and things that they look for with examples, of when a physician or practice did something wrong to, as an alert, as a learning exercise. There's plenty of materials out there that can help you and guide you if you have questions. So I would definitely suggest to everyone to go to the OIG's website and look at their compliance plans. They have compliance plans for small practices, large practices, hospitals, so they are fairly tailored to whatever need you have. Another important thing to have is an office policy and procedure manual. Every practice should have, obviously practice policies and a practice manual. In your office policy manual, you should definitely have a section about proper medical record documentation. When, for instance, when you should close out on a note, because depending on who you're billing, what entity you're billing, what code you're billing, what services you're billing, a note has to be closed within, a certain amount of time after the patient visit. So you need to have some documentation in your practice to protect yourself, in case you have a rogue physician who's not following the proper practices. You don't want the whole practice to go down for the conduct of one physician. So you should include a section about proper medical record documentation. You have to ensure that all the staff is properly trained, and you have to develop a policy for internal and external auditing. A lot of practices do have a billing department, someone who's been doing billing for years, and without disparaging that person, you just don't know if that person's been doing it for years the wrong way or not. You have to also allow for these people to be trained, to go to seminars, to stay updated on code usage, and attend webinars and attend different conventions, because this is something that's vital. You need to be able to build the right code, and they're constantly changing, so you certainly need someone who is devoted to that. And whether you use an outside or inside person to do your coding, you should think of getting a completely separate independent company to take a look at whoever your coder or your biller is to make sure that they're audited and doing everything correctly. So being prepared and staying compliant. So what are some of the tools of the trade? Some of the tools that our own coders that we work with on time to time, what do they use? Well, medical dictionary, medical abbreviations, that may sound a little basic, but I can't tell you how many audits have turned on a single phrase or just a couple of words. We were before a major insurance company here in New Jersey not too long ago in a recent case, and they essentially admitted to the fact that a number of this one physician's bills were being denied because his documentation didn't have 2 words in it. There were 2 words missing that, had the physician done that, he wouldn't have faced a $60,000 overpayment demand just to that code. It's a hard pill to swallow for any physician to know that had he or she used 2 additional words, it wouldn't have cost him or her $60,000. But that's why it's very important to really have a good knowledge of what's required by each code, because just noting something by checking a box isn't enough. Sometimes you may need to actually write just a couple of words to get your point across. Coder's handbook and desk reference, those are good so that you know exactly what the medical records should have. Obviously, CPT or ICD-10 and HCPCS books, again, for the same reason as a coder's handbook or code or desk reference. The 95 and 97, documentation guidelines, local coverage decisions from Medicare. I'm going to touch upon that real quick in a second. And then auditing tools. The one auditing tool that a lot of practices invest in and get a lot of good value out of it is software that scrubs your claim. So this scrubbing software, you can just put in, your EMR claims, and it'll tell you if, there are any red flags, if there's anything missing from a code, build, or if you are undercoding, or if you're overcoding. You can't trust the EMR's inherent coding output. Sometimes they suggest a code based on how many boxes were checked, and the more boxes you check, the higher the code. Well, that's not always correct, and that can get a practice into a lot more trouble. So we always suggest that you have a scrubbing software, or that if you're not going to invest in that and scrub every single one of your claims or a representative number of claims every month, you at the very least get an external auditor to just conduct an audit of your billing. You want to be prepared and stay compliant with local coverage determinations. That's something that the CMS puts out routinely. They're tools to assist providers, physicians, and suppliers in submitting the correct claims for payments. They're very helpful. They provide the correct coding guidance. They indicate where medical necessity needs to be shown on certain codes, and it gives you a very nice, easy to follow list of documentation requirements. So they're very educational. It's a free service from CMS, and I believe they come out every Thursday. So how to learn more? Of course, the 95 to 97 guidelines, they're available on the website that's indicated on the PowerPoint that you presented. Finally, what can you do to avoid, becoming entrenched in a long fight for overpayment demand? Make sure you have a good electronic medical record system. Not every EMR is built the same, especially if you're going through meaningful use attestation. You have to make sure that it's going to be able to pass at every level, so you don't face a repayment. And shop around, get the one that's good and that's tailored to your practice to the best of your ability. You want to do internal compliance audits. Audit yourself, audit your staff. Audit your own doctors on a monthly basis to make sure that there's not something that's being billed out and going out to insurers wrong. If you identify something wrong, you repay, Medicare for the overpayment, and you cut, you nip it at the bud. You want proper training for all billing staff, and if you're doing your billing, if you're outsourcing that, you got to make sure your outside consultants are qualified. This is one of the most important things, that you can do, because if you have a coder or a biller who doesn't really know what they're doing, doesn't have the most updated codes, doesn't get code books, doesn't get local coverage decisions from CMS, isn't up to date on everything, they'll cost you a lot more than they'll save you, if you get them. And then, we can't repeat this enough. You really should repeat audits and training regularly, because you want to make sure that everyone is on the same page. To learn more, there are more resources here on the PowerPoint presentation, from CMS, Medicare, OIG. Our law firm has some resources available for physicians as well. And, we suggest that you go to, coders as well to, really get the most out of, their experience, because you really do want to, draw the most you can out of a professional coder's experience when it pertains to what you should and should not be writing in your medical documentation when you're billing a code. So that's it for the presentation. If you have any follow-up questions or require any documentation or anything, you may contact Dawn, and she will forward me any questions you may have, any documentation that I referenced in this presentation that you may need. And I thank you very much for your time.
Okay, I'm going to open it up to any questions we may have. So if you have a question, please send it over to us. We'll keep the questions open for just a couple seconds here, and if not, you can follow up with Guillermo afterwards. Looks like we do have one question so far, Guillermo.
Okay.
And the participant says, I missed the beginning of this. Does this webinar apply to traditional Medicare or also includes Medicare Advantage patients? We have 150 patients, United Medicare Advantage record review. We are a 3-physician practice.
Yes, that's probably one of the first things that I said at the beginning. This, the strategies here that I discussed, the issues, they're applicable across the board. Although I discussed specifically, the different levels of Medicare appeals, how you get on the radar, how you should respond, how you can, avoid being a target in the future. All that applies across every kind of audit, including, Medicare Advantage patients, Medicaid patients, private insurers, basically every audit.
Another question just came in. Just a point worth mentioning, just because a coder is certified, it does not guarantee that they are well-trained and knowledgeable. I guess that's a little more of a statement than...
Oh, no, I completely agree with that, too. That's why you have to really audit somebody because, just like there are good doctors and bad doctors and good lawyers and bad lawyers, there are some good coders and there are some terrible coders. And one of the things that's particularly difficult when you're dealing with coders is that what they do is part art, part science, because you can sit a room full of 10 coders and have them review the exact same thing, and there will never be a consensus because some will think it's one code higher, one code different. That has been proven. So you're absolutely right, and that's a comment that I'll definitely agree with.
Okay, another question. What are those 2 words missing from the documentation?
Oh, that was a very particular. He was that physician was an ENT, so it was particular to his practice. I don't recall off the top of my head what the 2 words were, but they were to describe. They were tied to the not the medical necessity, but to the procedure that he performed. For instance, it's like something saying like, with debridement or something like that. It was 2 additional words that, in the case of that very specific factually, that one doctor, it cost him unfortunately a large sum of money. But I don't know those particular 2 words, and it wouldn't really help you unless you have the same exact problem. That's why, we just suggest read local coverage decisions, have a good certified coder that you trust, that's been vetted by other practices, and then obviously audit them and self-audit, have someone self-audit you.
Okay, Guillermo, it doesn't look like we have any more questions. I'd like to thank everyone for attending. Again, the presentation will be emailed to all participants following the webinar today, and it's also available on our website under the Members Only section. Thank you all for attending, and we hope to see you at a future webinar.
Thank you. Thank you, everybody.